Mom is, you gotta love moms. All right, did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement? If for any reason the court doesn't follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Court will find that defendant. I'm sorry, just 1 second. All right, I see it now. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do when he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Thomas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state's proceeding on count 2. Punishment is to be assessed at 10 years in the prison. State is silent on your application. They're taking in consideration the following county court cause number 7000473 and 717551. Did you understand that to be the plea?
It's 10 silent, so we're going to go to the judge for punishment. When they do the pre-sentence investigation, and they're going to dismiss the 2 misdemeanors upon that sentencing date.
All right. Do you understand that I'll be the person who will make a decision on whether or not to grant you probation?
Yes, ma'am.
And do you understand that the state is going to be silent? So they're not going to say they don't want you to have probation. They're not going to say that they do not want you to have probation. What they will do is if there is some sort of fact issue, they will be able to speak to factual matters, but they won't be able to say, judge, don't give him probation, or judge, do give him probation. Do you understand?
Yes, ma'am. Yes,
Did you
ma'am.
understand that to be the plea?
Yes, ma'am.
Defense,
Yes, Your Honor.
state?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have been motions, but they've not been ruled upon. We were waiting for that to happen upon trial, Judge.
All right. Then to the offense in count 2, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence?
Your Honor, I offer State's Exhibit 1 and the attachments.
We've reviewed states 1 and all attachments, Your Honor. We have no objections.
Showing you the waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand today that the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Ms. Ferguson, when can we come back for sentencing? Oh, thank you. All right, so we're going to be back on November 14th. At that time, I'll make a decision on your application based upon the PSI report
Yes,
and
ma'am.
any other evidence that's presented.
Yes, ma'am.
All right, so that'll be a PSI and a TAP evaluation. Is there a need for any mental health evaluation?
No, Your Honor.
All right, thank you. We'll see you then.
Thank you. Thank you, Judge. Y'all have a good day.
Thank you. Who's here on Courtney Kretzer?
I'm here. Hey, good night.
Yes. All right, the next person up is Noah Moran. Is the attorney here for Noah Moran?
Yes, sir.
And then after that, Oh, I'm sorry. Just 1 second. You're not first. It is Mark Alvarez. And then after that, it will be your case. And state, do y'all have your fingerprint person? Have they already taken the print?
Are, I think in the 390.
He's been printed though, Judge, I know.
Okay.
On the stage.
Oh, not you.
I'm sorry. my
That's
bad.
okay.
I apologize.
Right after.
I'm multitasking.
I apologize. I should have known, Judge.
No, sometimes my multitasking is great, sometimes it's not. Court is calling 2023 CR 8797W and 2023 CR 8796W, State of Texas versus Mark Anthony Tino Alvarez. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
And Nico
Defense.
Kalfas on behalf of Mr. Alvarez, Your Honor.
And are you Mr. Alvarez?
Yes, ma'am, Your Honor.
Counsel, in each of the cause numbers, have you received all the discovery and that you review it with your client?
We have, Your Honor.
And each cause number, the court will find that the state is in compliance with discovery. And each cause number, Mr. Alvarez, I'm showing you what's entitled Waiver of Indictment, Reading of Information and Rights on Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review those documents with your attorney? Did you understand it and did you sign it?
Yes, ma'am, Your Honor.
Did you understand in each cause number, you have a right to have a grand jury review the evidence and make a decision on whether or not these cases should be indicted?
Yes, ma'am.
And did you also understand that your attorney has 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial?
Yes, ma'am.
Did you understand by entering these plea bargain agreements, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into pleas in each of these cause numbers?
Yes, ma'am.
Then in each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. In each cause number, Caroline, off the record for a moment, please. Numbers. Did you review the information
Yes, ma'am, Your Honor.
and did you understand the information? State, do you waive the reading of the information in each cause number?
Yes, Your Honor.
State, are you proceeding on the information as presented in each cause number?
Yes, Your
All right. Mr. Alvarez, in each cause number, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, Your Honor.
And cause number 2023 CR 8796W, you're charged with evading arrest, detention of a vehicle. And in cause number 2023 CR 8797W, you're charged with DWI, third or more. Those are both third-degree felonies. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes,
There are no applications in either of these cases.
no, ma'am, Judge.
All right. Did you understand in each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am, Your Honor.
Did you understand by entering these plea bargain agreements, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into pleas in each of these cause numbers? Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Alvarez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you what's entitled plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
In each cause number, your plea is punishment be assessed at 9 years in the prison, no applications. The cases will run concurrent. The state will take in consideration the following night mag numbers: 704498, 704692, 727545. And if you are not present on your sentencing dates, you'll be subject to the full range of punishment. Did you understand?
Yes, ma'am, Your Honor.
Is that the plea?
It is, Your Honor.
Is that the plea?
Yes, Your
In each cause number, did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, Your Honor.
Counsel, have there been any such motions in either cause number?
No such motions, Your Honor.
And cause number ending in 8797W, which is driving while intoxicated, how do you plead guilty, not guilty, or no contest?
I'm guilty.
And cause number ending in 8796W, evading arrest detention, how do you plead guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence to support the defendant's guilty plea?
Your Honor, in each cause, I offer State's Exhibit 1 in the attachments.
No objections, Judge.
In each cause number, I'm showing you the waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, and cause number 2023 CR 8796W, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. All right, and cause number 2023 CR 8797W, court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding to sentencing?
Your Honor, we're going to ask the court to humbly reset us for 30 days for sentencing. He's been on bond. He's been, one of his bondsmen on one case had filed an off bond, but there was an affidavit also filed since then to reinstate the bond. And so we're asking the court to reinstate his bond and allow him 30 days to wrap up some of his personal affairs. He has personal property both at his mother's house and the mother of his children's house, and has been living actually there. And we would like to just get his personal items all in order and together. Additionally, he has 4 children and a stepchild he's very close to. And he'd like the opportunity to say goodbye to him before he does his 9-year sentence.
All right, State, do you have any objection?
No, Your Honor, it's just as part of his plea agreement, he is open to the full range of punishment if he fails to report. So we just asked the court to admonish him that he's open to the full range. If he doesn't report on the day, he's supposed to report, Judge.
All right. So, Ms. Ferguson, can I have a 30-day reset? Yes. All right, we're going to be back on November 9th. Is there any objection to the court? The bondsman wishes to go back on the bond, and it's the court's understanding that the bondsman, the reason for his not having a bond is simply just because the bondsman got off his bond and for no other reason. Is that correct?
Correct, Your Honor.
Yes.
And so now the bondsman wants to be back on his bond. Any objection?
No objection. Judge.
All right. And I know this is not an application. What are the cases that you're taking in consideration? Are those drug cases? What are they?
It's DWI third and the next
Being
being
drug, the available, pleading to the evading, we're pleading to a DWI, and there's gonna be a DWI that's TIC and just some drug cases. I said just some drug cases, some drug cases.
All right. If you all will make sure that, here it is. Thank you, Caroline. You had it waiting for me. All right, this is what the court is going to do. I know it's for time, but probation, can you just do a preliminary probation? Have him talk to a probation officer.
Is this
Officer.
Mr.
Mark Alvarez.
Mark Anthony Tino Alvarez?
Yes.
He's already on probation, Judge.
Oh, he is?
Yes, sir.
Oh, well, we don't need to do that. Okay, so
There's a motion to revoke on file.
Okay. Okay, all right, we'll take up the MTR when we come back then.
Very well.
All right, so we can go off the record. Mr. Alvarez, you need to make sure that you are here, you understand?
It's
right. They'll give you a reset form.
So, but I should see this one come back.
All right, Noah Moran. And then if we can, Deputy Laura, I guess she can check to see if the jurors are here. All right, and State, do you have your fingerprint person already done? Oh, and I've recalled it. Court is calling 2023 CR. Sorry, Brittany, do you have the? You come in stealth.
He's on the stand in the 399 right now.
All right,
and
so-
he's in heavy demand. So our officer is here, like our SAP officer.
All right,
is
well,
here.
we'll take that up. Once Deputy Laura lets me know all the jurors are here.
Okay.
Court is calling 2023 CR 3133A, State of Texas versus Noah Angel Moran. Can I have parties announced for the record for the state
Hank Wilkins from the state, Your Honor.
defense?
Joseph Russell.
And are you Noah Moran?
Smith.
Both parties, we're only pleading to one case, is that correct?
Yes, sir.
Right.
Yes, sir.
Counsel, have you received all of the discovery? Did you review it with your client?
Believe I have and I have to review it.
Court will find that the state is in compliance with discovery. Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
You do, Your Honor.
Next, I'm showing you what's entitled. State, are you proceeding on the indictment as presented?
Yes, sir.
Yes, Your Honor.
Showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with the offense of aggravated robbery? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
No.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he was.
Mr. Moran, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea? Satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 8 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon, no applications. State will take in consideration 2023 CR 3134, 3135, and 3136. Did you understand that to be the plea? Defense?
Yes, Your Honor. subject to
State.
court ruling.
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments.
No
Any-
objection, Your Honor.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Judge, we would ask if the court would grant us either a preliminary PSI or a sentencing date. I did confer with the state. Jason Garrett's not here. He said that he didn't object to it, but he would ask for the language if he fails to appear that he's subject to the full range of punishment, which,
I mean, how old is he?
what did he say? 18. He's 18.
He doesn't have any, but what affairs does he have to get in order? He's 18.
Mom and dad are wanting to have him, wanting to spend a little more time with him.
Court is not going to allow that.
Well, maybe have a PSI though, I'd like for him to go with the PSI though, the prison.
I mean, there's no need for a PSI. You both have agreed to 8 years in prison.
I think there could be some mitigating circumstances that I can provide for when he gets sent.
Yeah, I mean,
We ask if the court would grant it.
I don't think legally there's a necessity for a PSI report. Is he on GPS?
Yes,
Is he on full house arrest?
yes, sir. He's made every court appearance. Hasn't had any violations.
State?
Your Honor, we'd ask that the same language, that defense counsel mentioned, just the court would admonish the defendant that if he doesn't show up, he's looking at the full range of punishment. So
If you don't show up, you're looking at life in prison. Do you understand?
Right.
And since this is an aggravated robbery, life in prison, you'll be doing a minimum of 20 years, day for day, if you do not show up. Do you understand? Ms. Ferguson, put this at the end of October. All right, you're coming back on October 30th for sentencing.
Thank you, Your Honor.
They're all here?
Yeah, approach, Judge.
Yes. Ah, okay. All right. Thank you. Well, it's going to be a long day since they accidentally sent him back. Mhm. Mhm. Okay, all right. And who is his attorney? All right. All right, and oh, he's here. Okay, do you know if is John able to come by? All right. Ms. Ferguson, on Ernest Ramon,
He's a walking.
yeah, we're gonna recall the warrant. Caroline, we're gonna recall the warrant on that.
Yeah.
And then we're gonna reset this in 2 weeks. Yes. What date, Ms. Ferguson?
What is it for?
It's VTC. All right, so we'll come back on October 17th. And Caroline, if you could recall the warrant on that one. Thank you.
I'm sorry. It's not on the pocket. I'm sorry. Yeah. we just got this. Judge, they call me to go down.
Okay.
We're gonna give you a reset form.
All right, thank you. All right, so there's been a mishap. Oh, it's just gonna be that trial is gonna start later than anticipated. It happens.
On his way.
Okay, thank you. Ms. Russell, your client is on his way.
Perfect.
All right, Ernest Morales. Yes. Yeah, but there was some issue with the dates you had. So we're just gonna bring him back on the 17th. Yeah. All right, just one moment. Hello? Oh, I will let them. All right, I will, Mom. All right, bye, Mom, ASAP. I love my mom. Okay. Is this gonna be two cases?
Well, it's the same defendant.
This is sentencing.
And
Okay.
it's
Just give me one moment.
Be here by 9 o'clock.
All right, court is calling 2023 CR 3934 and 2023 CR 4112, State of Texas versus Ernest Morales. If you guys could stand back a little bit. Could I have parties announced for the record for the state
Hank Wilkins for the state, Your Honor.
defense?
I need that Bettis Garza for the defense judge.
And are you Ernest Morales? All right, you entered a plea in each of these cause numbers on August 29th of no contest. Count 2 was waived in cause number 2023 CR 3934. I'm reading someone's. And the Judge Harrell found that the evidence was sufficient to find you guilty in each count. Have both parties had a chance to review the PSI report, state
Yes, Your Honor.
defense?
Yes.
Any objections to the PSI report, state
No, Your Honor.
No, Your
defense?
Honor.
According to your plea bargain agreement, the state is silent on your application. Counsel, do you have any witnesses or evidence?
No, Judge, I spoke to, this proffering, Your Honor, I spoke to Mr. Morales's boss, who was supposed to be here today. And he did corroborate, what is in the PSI report, that, he will allow, Mr. Morales to live with him. He's been his employer for a long time, and, that he'll support him, should the court grant him.
All right, anything you wish to say, Mr. Morales? Why should I grant this motion?
Oh, Your Honor.
You can raise your right hand. Do you solemnly swear or affirm the testimony, right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record.
Mr. Morales.
All right, and the reason why I asked you that question is because you've been on probation before and you've had motions to revoke filed against you before. So why should I grant you probation?
Well, this time, the only reason why I didn't report, Your Honor, to be honest with you, is from the bottom of my heart, I had an immigration hold. So when I got released from here on probation, ICE picked me up from here. They took me to their facility and they released me in an hour because I'm legal to be in here, you know what I mean? They never told me I was supposed to report back over here and do all that again, you know? So in my eyes, they was like, well, I mean, you're free to go, you know? I mean, they never
Well,
said.
let me ask you, are you a US citizen?
Yes. Yes, I am.
So why is ICE picking him up if
This
he's,
was back in 05, Your Honor. I believe this was back in 05. Is that what the court's referring to?
yes, well, I'm just,
And I think now he's the.
Yeah, I have
he's
a,
permanent
yes.
legal resident, so now he does not have any kind of ICE hold. I think maybe the time frame has elapsed.
well, did anybody before pleading him to these cases ask what the permanent legal resident is pleading to any of these cases going to affect his status as a permanent legal resident?
Well, Your Honor, when I read the PSI, is when I learned.
All right, so here's the thing. I can accept this plea and do whatever I want to do, but if something were to go wrong in this case, if he were to have a motion to revoke, the first thing it's going to be is a motion for new trial, and the motion for new trial is going to be granted because he needs to have an attorney, immigration attorney, tell him what the consequences of entering this plea are, because otherwise it will come back on appeal. And I will tell you what the Supreme Court has said, what the appellate courts have said, that if someone is not a citizen before they enter a plea, they need to talk to an immigration attorney, talk to the consulate, and if not, then we will start this process all over again. So I am not going to sentence him. Not going to sentence you. What we're going to do is I will have this plea stand. I will have you speak to an immigration attorney. And then if after speaking to the immigration attorney, you still want this plea to stand, this plea will still stand. Okay? But you need to make sure that you've spoken to an immigration attorney, because otherwise you haven't knowingly and voluntarily entered into a plea. Because the knowingly enter into a plea, you have to know the consequences of it. And if you don't know the consequences of it, you haven't knowingly entered a plea. All right? So you're appointed.
Yes, Judge.
Can we get somebody from MAC?
You can do, surveys,
All right.
and I'll contact her, after. And let her know what's going on.
Judge, there's, Mac is here.
Hi,
They got here very quickly.
thank you. All right, so Mr. Morales has entered into a plea.
Okay.
But he is not a citizen.
Okay,
So Ms. Ferguson, how long is it going to take you all to give him information? He's a permanent legal resident now. All right, so Norma, let's call this back for the end.
Judge, I don't think I have an immigration attorney, that's what I was told. I may be wrong. I don't work at that.
what was that?
Do y'all have an assigned attorney?
We can get exterminated.
I'll see if they're name.
Okay, so is she there or is she not there?
No, she works for the public defender's office.
All right, is she going to be available?
That's what we've been doing, Your Honor, for our,
I
for our
have her-
immigration.
I have her number.
All right, well, we'll have her.
Send her the order for her to appoint her, and then I'll make sure that she does it. Let her know that I'll explain everything that's going on.
All right, so what date are we coming back?
Do you want to wait till the 19th to come back? Sir?
Yes, we can put it on October 9th. Well,
The 19th?
put it in the following week because they may not be ready. Do you think they're gonna have it done? Yes, the 26th.
Sure.
All right, we're gonna bring you back on the 26th. And counsel, if you all have that information with the immigration attorney before then, just let the coordinator know and we will take it up.
October 26th, Judge?
Yes.
I have Sarah make over. And I'll
Yeah,
forward it.
yeah, I mean, I-
Thank you. Sorry, just.
Oh, no problem. There we are. All right, Lisa Anderson.
Judge, we didn't receive notice on that. That's why I wasn't even aware that we were set and she's not here. I double checked both with my staff and my email again for the second time. I didn't receive notice on it.
Well, did an email, a mail would go out to her at her address. Did you call her?
I haven't called her yet. I just found out about 20 minutes ago.
All right, if you want to call her and see where she is.
Okay.
Thank you. Caroline, is that everybody on our docket today? Yes, I gave that back to you, I think.
Oh.
Haven't? No, we did that.
Oh.
Yes. Yes.
Yes, please. Come back. She didn't want to. Oh,
No. Oh, yes, Michael Moore. I'm looking at Noah Moran. Yeah,
You didn't want to reach it out.
yes.
It's for stop.
Oh, the state or somebody can give me the criminal history. I think they can do the NCIC. I'm sorry. Oh, we'll just take that up when we come back on the day. Yes.
I saw this. Really nice people in the courtroom. It hasn't been very pleasant today.
Delightful.
Yes, okay. Yeah, this is good. Sure. Yes.
Jurors are ready. They're lined up and ready to go, Judge, whenever you're
Oh,
ready.
we have him here now.
Yes.
Okay.
That was. That's a good receipt.
Yeah.
Oh, my God. What are the odds?
Please, hi. Yes. All right, you two. The only thing we have left is Lisa Marie Anderson. That's probably going to end up coming back on Monday or something. Her attorney says that they didn't know. Mm-mm. We finished
accepted in
with
the box.
Saxon,
Okay.
Roger Villarreal. That's gonna be.
It specializes in
recalled
migraines.
Because he didn't know the comms. So if you will get with Bashan. Kretzer was dismissed. Blinko, we're recalling that. Yes. Yes. And then Jose Castagnon, if you could write in the file, because I see that's being recalled for March 23rd.
I mean, she's gonna make that final call. She's your.
Ah. Okay. Recall that for next week, because we need to figure out about his vet situation. Yes, the 19th. And then Tamar McIntyre. Okay. All right, and I think that's. She didn't show. Recall it for tomorrow. And then I think that's it. And here's. My. You're welcome. All right.
We'll each get a chance to review it, make any objections.
Okay. All right, we're going on the record in 2023 CR 2674, State of Texas versus Todd Dotson. If I can have parties announced for the record for the state.
Zach Dunn for the state.
Defense.
Elizabeth Russell for defense.
Haley, please, for defense.
And are you Mr. Dotson?
Dodson.
All right, thank you. And state, sorry for talking over you, Mr. Banks. All right, my understanding is the jury is here. Are all parties ready?
Yes, Your Honor.
Yes, Judge.
And was there going to be an objection to the reporting officer or no? The court was informed that Ms. Russell informed the court coordinator that there are not going to be a hearing on that. Is that correct?
Yes, Judge, we withdrew our objection. We appreciate the court's time allowing us to prepare yesterday. It was exactly what we needed.
All right, so there is no objection to this witness testifying?
There is no objection, Judge.
And then something else that we need to put on the record that was not placed on the record. One of the jurors was ill, and off the record, neither party said they had any objection to excusing that witness. Is that correct, state?
Yes, Your Honor.
Defense?
Yes, Judge.
All right, let's bring in the jurors.
Okay, all rise for the jury.
And if you'll call your witness.
Yeah, right now, Your Honor.
That was the alternate.
Oh.
Yeah, we already put the alternate.
All right, everyone, please be seated. State, call your next witness.
State will call Officer Lopez, Your Honor.
All right, if you'll take a seat here, please. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. If you'll state your name for the record, please keep your voice up so that the jurors can hear and the court reporter can hear.
My name is Jonathan Lopez.
All right, state.
Now, Officer Lopez, you say that you're an officer. For clarity, where are you an officer?
I'm an officer with San Antonio Police Department.
And how long have you been an officer?
It'll be 4 years in February.
And what do you have to do to become an officer?
We go through it's like 7-8 month academy, and then we have yearly training just to keep us updated on statutes and regulations.
And in broad strokes, officer, what does your job entail?
Mostly just handling calls for service. If a civilian calls, we respond, and we just help them as best as we can.
Now, officer, regarding domestic violence, family violence calls or calls within that sphere of influence, how frequently have you responded to those types of calls?
I would say that's probably the majority of our calls is family related or family violence related.
And if you had to put a number on it,
Hundreds,
now, officer, do you know why you're here today?
yes.
Regarding this incident, officer, do you know the date and time that you were dispatched?
I'm pretty sure the date was January 17th. I don't remember the time.
Would it help refresh your memory if you were to see a report from that date?
Yes.
Your Honor, may I approach the witness?
Yes.
I apologize if I already asked this. Your Honor, may I approach?
Yes.
For the record, please reflect that I'm handing the witness what's been pre-marked as State's Exhibit 15. Officer, please feel free to use this report to refresh your memory, but please do not read directly from it. Officer, I'll ask again, for clarity, what date and time were you dispatched?
Date would be January 17th, 2023, approximately 19-24 hours.
And where were you dispatched?
It's 202 Estate, San Antonio, Texas.
Is that location in Bear County?
Yes.
Now, officer, what information were you given prior to your arrival?
I was given, I believe the call note said there was the complainant called and said that the defendant punched her, hit her, something in that nature.
Now, officer, when you arrived on scene, did you make contact with anyone?
Yes, I made contact with the complainant.
With the complainant, okay. And is that the first person you made contact with?
Yes.
And what was their general demeanor or kind of physical condition?
She seemed concerned or worried. I've talked to her before, so I know who she is.
Regarding this incident, though,
Yeah.
how long after, to the best of your knowledge, was that phone call placed to when you arrived on scene?
I don't. I believe the call came in at 1911 and I got there at 1924.
Your Honor, may I approach again?
Yes.
Officer, I'm showing you what's been pre-marked and admitted into evidence as State's Exhibits 8 through, I believe, 14. Do you recognize these photos?
Yes.
And if you want to take just a quick second to take a look at them, what are they photos of?
These are photos of the complainant at the time of the report. Showing she has a bruised right eye.
And officer, after you made contact with the complainant, did you speak with anyone else on scene?
I spoke with her roommate.
Okay. Was the defendant on scene?
No.
Officer, did you make any arrests that night?
Yes.
Who did you arrest?
The defendant.
You've mentioned the defendant, just for clarity and for the record, is that individual in the courtroom today?
Yes,
Can you please identify them by an article of clothing?
he's wearing a blue jacket and khaki pants.
Your Honor, may the record please reflect that the witness has correctly identified the defendant. Now, officer, if the defendant wasn't on scene, where did you make that arrest?
We were told it was his grandmother's house. But you want the address? Or?
Officer, after you were told that, what action did you take?
Me and my partner relocated to the grandmother's house and knocked on the door to see if he was home.
And was anyone home?
Yes, his grandmother's home and he was there. We saw him in the kitchen.
And officer, in every report, every scene that you arrived to, are you required to make an arrest?
No.
Did you make an arrest that day?
Yes.
And speaking to the 17th, what factors on that date led you to make an arrest?
Just the fact that she had a visible injury. It was family violence related, and he had a outstanding warrant that we knew of. So,
Just a moment, of course, time, Your Honor. Officer, when you made contact with the defendant, what was his general demeanor or attitude?
Objection of evidence,
Overruled.
he seemed confused.
objection, speculation,
Overruled.
You may answer the question.
He
officer.
seemed confused as to why we were there and how we got the address.
Did he say anything to you?
I can't remember exactly what he said.
Pass the witness, Your Honor.
Defense.
thank you, Judge. So Officer Lopez, it was your understanding that the alleged offense on the 17th of January had occurred at 11 p.m. at night, isn't that correct?
It occurred the day before.
So you arrived on January 18th, right?
I arrived on the 17th. I believe she reported it happened on the 16th.
So it actually happened on the 16th
Yes,
at 11 p.m.
approximately 10. She said 10 p.m.
And you didn't arrive till the 17th, till around 7:20, 7:25. Is that accurate?
Yes.
And so I know I asked really short answered questions. And so if you can just wait until I finish and then answer.
Yes, ma'am.
Thank you. And that's because the complainant hadn't called 911 until approximately 7 p.m. on January 17th. Is that accurate?
Correct.
And officer, were you wearing body worn camera that evening?
Yes.
And do you typically wear a body worn camera when you respond to these types of calls?
Yes.
And how many times have you testified in district court before?
Objection, relevance?
That'll be overruled. You can answer the question.
This is the first time I testified.
Welcome. And your body worn camera, did you have a chance to review that body worn camera today?
Yes.
May I approach the witness, Judge?
Yes.
Officer, do you recognize this disc?
Yes.
And did you just finish reviewing the body worn camera back in the witness room?
Yes,
And did you bring that computer to me with the disc still in the player?
I think somebody else brought it, but
But the
it was
computer,
the one I was watching.
thank you. And did you see me just remove the disc from the laptop and the CD player? And so is this a full and accurate copy of your body worn camera from the January 17th investigation?
Yes,
And has it been altered or changed in any way?
not that I noticed.
And so, Judge, at this time, defense would move defense exhibit 1 into evidence.
Your Honor, the state will object on multiple layers of hearsay contained within from multiple individuals.
All right. On defense exhibit number 1, are there people speaking on that?
Yes, Judge, and we have 3 exceptions.
All right. And what are your exceptions?
Number 2, exception number 2, exception number 3, and exception number 5. So exception number 5, that this was a statement that was made at or close to the time of the event. It was made at the night of the incident. And because of that, it is more accurately reflective of what happened that evening. Would you like me to continue?
Oh, sure.
With the rest. Exception number 2, it was an excited utterance, and exception number 3, just take a touch.
Would you like a code book?
No, Judge, a then existing mental impression of the events.
All right. State.
Your Honor, this isn't a then existing impression. This is from the next day. It's also not an excited utterance. Again, this is from the next day. And with respect to whether being on or close to, typically the state has seen those type of exceptions for Crawford if you want to make an ongoing emergency argument. But certainly the state does not believe that 3 people's statements the day after overcome a hearsay exception.
All right. And who are the 3 persons?
The 3 persons, to the state's knowledge from reviewing, would be the complainant, the Bridget, the woman that testified yesterday, and this officer.
All right. The objection will be sustained.
No, officer, the first person you talked to when you arrived at the scene was the complaining witness, Sabrina. Is that accurate?
Yes, ma'am.
And when you talked to her and asked her what happened that evening, the other witness, Bridget, was also present. Isn't that accurate?
Yes,
And isn't it SAPD policy to separate witnesses when you question them about events?
it is.
And that is to ensure that you have evidence that can be corroborated separately. Isn't that accurate?
Correct.
And so were you concerned in this situation that the witness, Bridget, had overheard your conversation with Sabrina?
It's possible. I did separate him when I got her official statement, but at the time of when I was talking to Sabrina, she was there. Bridget was
Okay.
there.
And so who all was present the night of the incident?
As far as I believe, it was the complainant, their roommate, Bridget, and I think the children.
And the roommate saw Mr. Dotson that evening on the night of the incident. Isn't that accurate?
Yes,
She even went into Sabrina's room that evening. Isn't that accurate?
Objection, speculation.
Sustained.
May I at least respond, Judge?
Yes.
He was told that, so I don't think you have to speculate. I can lay a better foundation.
All right.
Your Honor, the state would then object to hearsay.
Sustained.
Now, based on your experience investigating domestic violence incident, different people have different responses to injuries. Is that accurate?
like physical or emotional, or are you referring to like emotional responses?
I guess it could be either. Let me clarify for you. So different people bruise differently. Is that accurate?
Yes.
And some people bruise right away.
Correct.
And some people, it takes a while for bruises to develop.
Right.
And there was a concern that Sabrina's bruise was already so developed, wasn't there?
Not really, no. If it happened the night before, the bruising it seemed consistent with the timeline.
But an officer was sent to the scene after your initial investigation, back to the scene, to ask Bridget when she first saw the bruise. Isn't that accurate?
I'm not sure. I don't remember.
Now, initially you were under the impression that Mr. Dotson had broken into the residence, based on your investigation. Is that true?
I would say broken in. She couldn't tell me how he got in, but it was I was under the impression that he entered without consent.
And she had said that she had just changed the locks 2 days prior, right?
Yes,
And that she hadn't seen him since that time.
correct.
And so later on in your investigation, you learned that one of the children might have let him in.
Objection.
I'm sorry, what is your objection?
Oh, it'd be hearsay, Your Honor.
Judge, it didn't call for a statement.
All right, that would be sustained.
Now, you had some concerns about the credibility of Bridget. Isn't that accurate?
The stories were the statement from the complainant and the statement from the witness were conflicting.
They were conflicting. If you have no further questions, Judge, we pass the witness.
All right, stay.
Just a moment of the court's time, Your Honor. Officer, did Bridget ever tell you that she saw the assault?
No.
So any inconsistency would not have been. with
Objection,
respect to-
speculation.
All right, let me hear the question, then you can make your objection.
So any inconsistency between the two accounts would not have been with respect to whether or not an assault happened that night, correct?
Objection, speculation.
That will be sustained. If you want to rephrase your cat question.
Now, officer, you testified on cross-exam that there were inconsistencies.
Yes.
And then I asked you if there were any did the eyewitness tell you that she saw what happened that night?
Objection leading, objection hearsay. Objection calls for speculation. And that's
With regards to speculation, that's overruled. With regards to hearsay, the hearsay objection will be sustained.
So were the inconsistencies you heard with respect to whether or not the assault happened?
objection calls for hearsay. Objection.
Overruled.
The only
Judge, I
inconsistency.
have two other objections.
Yes,
Also to speculation, also to asked and answered.
overruled.
The only inconsistencies was how he entered. It didn't have anything to do with the assault or.
Thank you, officer. Stay past the witness.
Defense.
And that's because I'm sorry, that's because Bridget didn't see the assault. Isn't that accurate?
Yeah, Bridget told me she didn't see this.
So she didn't tell you at all what happened during the alleged assault, so that she couldn't be inconsistent, could she?
Objection, compound question?
Sustained.
So Bridget didn't see the assault at all. Isn't that accurate?
Objection, asked and answered.
Overruled.
She told me she didn't see this.
So would it have been did she even give you any type of inconsistent statement with the alleged assault as Sabrina?
I'm sorry, can you repeat that?
Did she give a consistent statement in regards to the assault with Sabrina?
No, she says she didn't see it, so there's no statement about the assault.
No further questions, Judge, we pass.
Nothing further from the state, Your Honor.
All right, is this witness excused or subject for recall?
Excuse for the state, Your Honor.
Excuse, Judge.
All right. The rule has been invoked. What that means is you can't discuss your testimony with anyone. You're not allowed to speak to anyone except for attorneys for the state or the defense. Do you understand?
Yes, ma'am.
All right, thank you. State.
Just a moment of the court's time. Your Honor, to the state's knowledge, the only fingerprinter available.
Just 1 second.
I apologize.
All right, ladies and gentlemen, I'm going to give you a reset because there's an issue that I need to take up outside your presence, okay? So you've heard some testimony. Remember my instructions. You're not allowed to deliberate internally, deliberate with each other, look at anything, discuss anything about this case. Everything that you need to know is to come from inside the courtroom. Does everyone understand? All right, everyone, please rise for the jurors. Oh, thank you. It's from Mom. Oh, you take breaks, China.
My apologies. I was zooming, so my
No,
apologies.
no problem, because you never know, a fingerprint person may look at the prints and say it's not his prints.
Absolutely, Judge. Absolutely.
All right, so where's the fingerprint person?
Your Honor, we have just sent our advocate down to the 399th in person to see what the latest update is.
All right, okay, we'll wait for that.
Yes.
Told her to stay down there and send us live updates.
Okay, great. Oh, and just everyone here's the charge. And you all can be looking over that, and if there are any objections or anything, just let the court know.
Absolutely.
How long are we gonna get for closing, Your Honor?
I think 15 minutes each side is about.
You're gonna ask for 45?
I know that. All right, everyone, please be seated. Call your next witness.
The state calls Brianna Gaddison.
Raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth so help you God?
Yes,
All right, you can lower your hand and if you'll state your name for the record.
my name is Brianna Gaddison.
And you'll spell your last name, please.
My last name is gonna be Gaddison.
All right, state.
Good afternoon. First off, what's your occupation?
I'm a fingerprint examiner at the Bexar County Sheriff's Office.
About how long have you been doing that?
Just over a year.
Do you have any, what's your area of expertise?
I know how to compare fingerprints, and I classify fingerprint cards.
Do you have any certifications?
Yes, I do.
What certifications do you need to do that job?
You need a fingerprint classification certification that's given by TCO, which is Texas Commission of Law Enforcement.
And what's the like training process like?
The training process, well, we have to take a 40-hour class where we learn about different fingerprint patterns, we learn how to classify fingerprint cards, and how to identify if fingerprints match each other.
Excuse me, you can back up from the
Oh, sorry,
microphone. a little.
sorry.
That's okay. Just keep your voice up.
Okay.
And ever since the course, how long have you been doing fingerprint comparisons?
Probably like a year, I would say.
Okay, and how many comparisons have you made?
Probably over 1,000, I would say.
Okay. Have you testified as an expert in as an expert witness in the area of fingerprint identification?
No, I have not.
And let's start with the basics. What is a fingerprint?
Fingerprint is an impression of the friction ridges of the human finger.
Okay, and how is a fingerprint left on a surface?
How is it left on the surface? By the, I believe, the sweat on your fingers. Whenever you touch something, you leave an impression on your fingers.
And have you ever found two people to have the same fingerprints?
No.
Do you know of any case, even outside of your own comparisons, where two people have the same fingerprint?
No.
How do you make a fingerprint comparison?
We compare the points on a fingerprint to the two fingerprints that we're comparing. So we have to find 12 points on, I guess, the fingerprint that we have in front of us, and then 12 points on the fingerprint that we're given to make sure that they're a match.
And is that the standard way that fingerprint comparison is done?
Yes.
And are you a custodian of the records for, well, first off, what is the process when someone's arrested in terms of getting their fingerprint?
Well, they'll first get put in, and then an officer will usually take their fingerprints once they get to jail. And then they'll be put on this thing called a live scan, which is electronic fingerprints. And then those fingerprints will be sent to us where we compare those prints to what we have on file.
And with regards to a drop card, are those made when someone's arrested?
Yes.
Okay. And are you a custodian of the records for Bear County?
Yes, I am.
And did you bring any drop cards with you today?
Yes, I did.
Your Honor, permission to approach the witness?
Granted.
And which drop cards did you bring with you today?
This one and this one.
I'm gonna mark them with exhibit stickers. call them States Exhibit. Exhibit 18 and 19.
And I'm sorry, which one was 18 and which one was 19?
I can, permission to allow defense to. Okay. Your permission to.
Yes.
Ending what is marked States Exhibit 16. Let me show defense for observation purposes. States Exhibit 16, and compare States Exhibit 16 to States Exhibit 18. And States Exhibit 18 and States Exhibit 16, is there a name? Or first off, did you fingerprint somebody today?
Yes, I did.
Who did you fingerprint today?
The gentleman is sitting in the blue coat and light blue button down shirt.
And did you compare the fingerprints on the drop cards, States Exhibit 16 or States Exhibit 18 and 19 to the impressions that you got today? From the,
Yes, I did.
and were they a match?
Yes, they were.
Okay. And on the drop card for States Exhibit 18, and comparing that to States Exhibit 16, is there a name on the drop card and a name on the States Exhibit 16?
Yes, there is.
What is the name? Do they match?
Yes, it's Todd Joel Dotson.
Okay. And is there a night mag number on the booking sheet?
You said a night mag?
Yes, the NM number on the drop card. I wonder if I may approach.
Yes.
Judge, we're gonna object the prosecutor pointing to what evidence he's looking for from the witness.
All right, that objection will be overruled.
The NM case number.
Case number. Yes.
And on page 8 of States Exhibit 16, it's the second to last page. Is there also an NM number there?
Yes.
And are those the same?
Yes, there is.
They're the
see it.
same.
Yes, they're the same.
And is there an offense listed on the booking sheet?
Yes, there is.
And is there an offense listed on the front of States Exhibit 16?
You said on the map?
On the front page, yes.
Yes.
Yes. What, are they the same offense?
Yes.
Is there a date of offense on States Exhibit 16?
Yes,
And is there a date of arrest or booking on the drop card?
yes,
And are those, is the date of arrest or booking on or shortly after the date of the offense?
yes,
The state moves to enter State's Exhibit 16.
Defense.
No objection, Judge.
All right, State's Exhibit number 16 is admitted without objection.
And do you think, in your opinion, that the, because of the matching fingerprints on the date of the booking sheet and the matching name and case type and matching night mag number on all of the documentation, would you say that this is the same person?
Objection, compound question.
All right, that objection will be sustained. You want to,
Given the totality of the evidence, would you say that it's the same person?
yes,
Um, Your Honor, may I approach the witness one more time?
yes.
And I'm handing you what is marked State's Exhibit number 17. Can you compare it to State's Exhibit number 16
Mhm.
and note the case number at the top of the docket?
Mhm.
Do those case numbers match?
yes, I do,
Does the defendant's name match?
yes,
Does the date of offense match?
yes,
Would you also say that that's from the same defendant?
yes, I would,
Move to enter State's Exhibit 17.
No objection, Judge.
All right, State's Exhibit number 17 is admitted without objection.
No further questions, Your Honor, pass away.
All right, defense.
Thank you, Judge. Ms. Gaddison, so you have looked at over 1,000 set of prints
yes,
for identification purposes.
yes,
And have you ever found those prints not to match?
sometimes, yes.
How often?
Probably like one or two every week,
One or two every week?
yes,
And how many do you test a week?
probably like 200, I would say,
So less than 1% of the evidence you review doesn't match.
I would say yes,
Now, you testified that that no two fingerprints are the same.
yes,
Isn't it true that identical twins have the same fingerprints?
no, that's not correct.
Okay, please explain.
When we were born, everyone's born with different sets of fingerprints. So even if we are twins or if we have twins, they will not have the same fingerprints.
Now, looking at defense exhibits, I'm sorry, state's exhibit 17, that's the drop card, right?
17, 18, yes, 18, it's the drop card.
There is not an offense date listed that is the same. There's not an offense date listed on there, is there?
No,
And it's true that an offense date isn't the same as an arrest or booking date. Isn't that accurate?
Object to relevance.
All right, that'll be overruled. You can answer if you know.
That can be true, it's like a warrant.
And so do you see the date August 16th, 2010, anywhere on State's Exhibit 18? August 16th, 2010.
Yes.
Okay. May I approach Judge?
Yes.
And can you show me where you see it?
Right here.
So this is 18. On State's Exhibit 18.
Okay. You said, do I see the date of August 16th, 2010?
Yeah, that's accurate.
I think she's waiting for your question.
I was trying not to talk over you.
Okay.
Do you see the date August 16th of 2010 on State's Exhibit 18? No questions, Judge. We pass the witness.
Any further questions?
One more question. And so you, now that State's Exhibit 16 and 17 are in evidence, what's the name of the offense on the judgment?
On the judgment is gonna be assault, family, choking, and strangulation.
No further question.
Nothing further, Judge.
All right, is this witness excused?
Excuse from the state, Your Honor.
Yes, Your Honor.
All right, the rule has been invoked. What that means is you can't discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state of the defense. Do you understand?
Yes.
All right, thank you. State, call your next witness.
State rest, Your Honor.
Defense.
Defense has no witnesses. They rest at this time.
All right, state, do you close?
Yes, Your Honor.
Defense, do you close?
Defense closes, Judge.
All right, ladies and gentlemen, I'm going to read to you the charge of the court. Before I read that, though, I'm going to make sure that the court reporter grabs the evidence that's sitting here. So she just needs probably 2 minutes or less than to make sure she has that. And Dinah, it's 17 and 16. Excuse me, do y'all have exhibits 17 and 16?
We're trying to get that now, Your Honor.
Oh, you can. If you just, you know what, if you'll leave those up here, you can just put it on the bench here. And Donna, just let me know when you're ready. Okay. All right, thank you. All right, ladies and gentlemen, I'm going to read to you what's entitled charge of the court. It's the jury charge. You don't have to memorize it. You'll be given it when you go back to the jury room. Charge of the court. Members of the jury, the defendant Todd Jail Dotson stands charged in count 1 of the indictment with the offense of felony assault against a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship alleged to have been committed on or about the 9th day of January 2023 in Bexar County, Texas. The defendant Todd Jail Dotson stands charged in count 2 of the indictment with the offense of felony assault against a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship alleged to have been committed on or about the 17th day of January 2023 in Bexar County, Texas. To these offenses, the defendant has pleaded not guilty. 1, our law provides that a person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. Our law provides that a person commits a felony assault if the person intentionally, knowingly, or recklessly causes bodily injury to a member of the defendant's family, household, or a person with whom the person has or has had a dating relationship, and it is shown on the trial of the offense that the defendant has been previously convicted of the offense of assault against a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship. 2, family includes individuals who are married to each other and individuals who are the parents of the same child without regard to marriage. Household means a unit composed of persons living together in the same dwelling without regard to whether they are related to each other. Dating relationship means a relationship between individuals who have or have had a continuing relationship of a romantic or intimate nature. The existence of such a relationship shall be determined based on consideration of the length of the relationship, the nature of the relationship, and the frequency and type of interaction between the persons involved in the relationship. A casual acquaintanceship or ordinary fraternization in a business or social context does not constitute a dating relationship. 3, a person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of, but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 4, with respect to evidence admitted in this case concerning the defendants having been previously convicted of an offense against a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship, if he was, you are instructed that such evidence cannot be considered by you as in any manner proving or tending to prove whether the defendant intentionally, knowingly, or recklessly caused bodily injury to Sabrina Denise Alvarez on or about the 9th day of January 2023, in or on or about the 17th day of January 2023. 5, our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date. The statute of limitations period for the offense of a felony assault is 3 years. Therefore, it is sufficient if the state proves that the alleged offense was committed within 3 years before March 23rd, 2023, which is the date the indictment was filed. 6, count 1. Now, if you find from the evidence beyond a reasonable doubt that on or about the 9th day of January 2023 in Bexar County, Texas, the defendant, Todd Jael Dotson, did intentionally, knowingly, or recklessly cause bodily injury to Sabrina Denise Alvarez, a member of Todd Jael Dotson's family, household, or a person with whom Todd Jael Dotson has or has had a dating relationship, by striking Sabrina Denise Alvarez with the hand of Todd Jael Dotson, and before the commission of the alleged offense above on the 16th day of August 2010, and cause number 2010 CR 6597W in Bexar County, Texas, the defendant was convicted of the offense of assault, family, household, impeding breath circulation, an offense against a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship, then you will find the defendant guilty of the offense of felony assault against a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship as charged in count 1 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 1. 7, count 2. Now, if you find from the evidence beyond a reasonable doubt that on or about the 17th day of January 2023 in Bexar County, Texas, the defendant, Todd J.L. Dotson, did intentionally, knowingly, or recklessly cause bodily injury to Sabrina Denise Alvarez, a member of Todd J.L. Dotson's family, household, or a person with whom Todd J.L. Dotson has or has had a dating relationship, by striking Sabrina Denise Alvarez with the hand of Todd J.L. Dotson, and or by grabbing Sabrina Denise Alvarez with the hand of Todd J.L. Dotson, and before the commission of the offense alleged above on the 16th day of August 2010, and cause number 2010 CR 6597W in Bexar County, Texas, the defendant was convicted of the offense of assault, family, household member, impeding breath circulation, an offense against a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship, then you will find the defendant guilty of the offense of felony assault against a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship as charged in count 2 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 2. Your verdict in each count must be unanimous. If there is evidence presented of more than one alleged instance that could constitute an offense committed by the defendant against the complainant, if any, you are instructed that your verdict on each count must be unanimous about which specific instance, if any, constituted the commission of the offense in each of the individual counts. Evidence of any other acts alleged of misconduct by the defendant against the complainant in this case is not to be considered unless you believe those acts, if any, were committed beyond a reasonable doubt. With regards to those other acts, if any, you are instructed that said evidence was admitted, if it was, only for the purpose of showing the state of mind of the defendant and the complainant and the previous and subsequent relationship between the defendant and the complainant, if it does, and for no other purpose. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced into evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law, as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict. But jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and attached are verdict forms. State, are you prepared to proceed with closing argument?
We are, Your Honor.
All right, you may proceed.
Thank you, Your Honor. And please the court, opposing counsel, co-counsel, and ladies and gentlemen of the jury. He fled the scene both times. This is the man who, as you heard from Sabrina when she took the stand, he didn't always leave when he was told. He was someone who had kind of worn out his welcome. She was telling him to leave, but he wasn't leaving until the police came. That's when he fled the scene twice. And I think that, for one, shows his consciousness of guilt, that he knew what he had done was wrong. And I want to talk about Bridget's testimony for a moment. I think she was the most credible witness on the stand throughout this whole trial. She had really no interest in the end of this trial, what happened. She doesn't even live with Sabrina. She's really has no stake. And she got up and she said, she saw it happen the first time in the living room and into the dining room. She saw the spitting in the face, the slap. She saw it go down. The kids were in the house when it happened. And then the second time, she said, yeah, I was there. I think I saw him there that night. Don't really remember.
Objection, a mischaracterization of the evidence.
All right, ladies and gentlemen, you will remember the evidence as you received it.
So she gets up on the stand and tells you that she was there. She saw him. Don't really remember what happened, but she doesn't get up and tell you, yeah, I saw him hit her. Because she's not up there to lie or to embellish or anything. If she was up there to lie or embellish, she would have said, yep, saw it on the 9th, saw it on the 17th too. For sure, with my own 2 eyes. Couldn't mistake it. I think we should really listen to her testimony. And let me talk about something technical, the beyond a reasonable doubt standard and how it applies in this case. As we talked about in voir dire, it's a difficult standard, but what you're looking for in this case is, do you have a doubt? Is it reasonable? And does it go to one of the elements that the state had to prove in this case? And so let me talk about some of the doubts that defense might have raised, which the state would argue don't go to the elements of this case. I call them distractions. The first one might be like, did he spit in her face and then hit her? Or did he hit her and then spit in her face? Well, there's a doubt there, right? But I think either way, he hit her. So that really wouldn't take away from the elements of the offense. Another doubt might be, well, when she was texting him after the first time he hit her, was she texting him because she felt disrespected about being called the B word, or was she asking him to leave? Because you only told the police that you felt disrespected back then. Now you're saying you wanted him to leave. She probably wanted him. I mean, I don't think there's any doubt about that. But it doesn't go to the element of the offense. What she was texting him after he slapped. So that is another distraction. And there's another one. Well, I think this is just a classic case of blaming the victim. She said, well, Todd came back a week later and you didn't immediately call the police and get him out of there. Well, I mean, that doesn't go to one of the elements of the offense. People are allowed to make up temporarily with their abuser, or maybe it's not making up. Maybe she, as she said on the stand, you wouldn't give her phone. You would take away her phone. Maybe she couldn't call the police. So I don't think that there is that and trying to blame her for the abuse she suffered. So what I'm going to say to you guys is don't be distracted. You heard from Sabrina, you heard from Bridget, you heard from the other witnesses. I think Todd needs to be found guilty, and I ask you to find him guilty, and I ask to reserve the remaining bit of my time.
Judge, if we can have just a moment to prepare the court.
Yes.
Your Honor, the state's going to object to the use of this diagram.
It's a demonstrative, Your Honor.
Let me see the diagram. All right, with regards to that, the state's objection will be, what's your objection?
That, Your Honor, this is improper. It's not admissible. It's not in evidence, and it was almost entirely done by defense.
All right, that objection will be sustained.
And Judge, we're also gonna use the other list of the complaining witness, from the complaining witness's testimony.
Your Honor, at the time, the state also objected to this.
All right, that objection is sustained.
Can we have what rule they're citing? Because I have no idea what rule they're citing.
All right, they previously objected to that was not demonstrative, and the court did sustain that objection, so it's not admissible.
Right, but they objected under 901, and that's not the proper objection.
They objected to it as demonstrative. Now, whether they used the correct rule number, they said that they were objecting to it, that it was not demonstrative evidence, and the court sustained that objection.
They didn't object to the other one, though, Judge, the diagram.
All right, the court has made its ruling.
Now, this objected to this now and it was sustained and defense is
I'm
still
sorry,
thinking.
Oh, I'm sorry,
I am not, I'm
court
putting something.
reporter could not.
Oh, I'm just pointing out defense is, you sustain the objection on this and defense is still showing it to the jury. The state is renewing its objection.
All right, the objection is sustained, and you may take it down.
Thank you, Judge. May it please the court.
Yes.
State calls them distractions, but I call it the state having tunnel vision. They had decided that Todd Dotson had done this because he'd done something similar to this before. And they didn't want to examine the evidence. They didn't want to question their witnesses. They didn't want to prepare their witnesses. And they had already decided exactly what happened before they even reviewed the evidence. So the most important thing we're going to talk about today is the burden of proof. And the burden of proof is the thing that keeps our Constitution and our rights different from any other country in the world. And I'm going to talk about the burden of proof through a wall. And I'm going to tell you about different things that the state didn't prove or inconsistent. And I'm going to build bricks for you. And each one of those bricks are going to be a brick in the burden of proof wall. And at the end, you're going to have to ask yourself if the state is able to not only get over that burden of proof wall, that brick wall, but if they go beyond that brick wall, because that's what they were proved to. So let's talk about some of those bricks. The first 3 bricks are those other 911 calls that they didn't bring to you, the body worn camera that they didn't want you to see, and all those other officers that were there that day. When we talk about the 9th and the 17th, the complaining witness herself tells us she can't even remember what happened or who she told what to because there were so many officers. But you hear from one officer on the 9th and one officer on the 17th. And so we submit to you that those are the first bricks, the foundation, and the brick wall that is the burden that the state must overcome. Those 911 calls that they didn't bring, the body worn cam that they didn't want you to see, and all those other officers. Now, let's talk about the inconsistency. So we're talking about August 9th, August 17th. And we're going to talk about the date, where the offense happened in the house, order of events. Did Bridget witness it? What hand was used? What side of face? Closed or open hand? And was it a hit or a punch or what was it? And we're gonna talk you through the evidence through Sabrina and what she told police. Bridget and what she told police. Bridget and what she told officers. Sabrina and what she told police. And Sabrina, what she told officers. And then we're gonna do the same thing on the 17th. Right. So first, with Bridget and what she told officers, we didn't hear any of that from August 9th, right? We didn't hear anything. So there's nothing in this call. On the stand, she tells us what date it was, August 9th. She tells us where in the house he was. You remember, we have the diagram. I wish I could show it to y'all. And she says that he was on this side with Sabrina pinned up against the wall. So to the right of the door. She says it is a slap and then a spit. She never tells us about the necklace. Was she a witness? She says she was. What hand? She says left hand. What side of face? She says left. Open, and she says it's a slap. But then we hear from Officer Lopez. And he says that when we're talking about Sabrina, he says it's the same date. He doesn't tell us anything about where in the house. He doesn't tell us anything about the order of events. He says that Bridget's a witness. He confirms the hand, side of face, he confirms all this stuff, right? But then the most important person, and the state tells you that the most important, the most credible person is Bridget, but most important person here should be the complaining witness, Sabrina. She tells us some different stuff. She tells us the same date, but she tells us that he's on the left side of the wall, not the right. And then the order of events, she tells us it's a spit, then a slap on direct examination. But then on cross-examination, we find out that she actually says it's a spit, and then she grabs his necklace and yanks it, and then he slaps her. Why'd she leave that out? Well, did she leave it out because she was afraid that that would seem like a first aggressive move and he might be responding to that? So she didn't want you to know? Because she never told you that. But when I crossed her on it and I asked her, she tells us, yeah, I did tell him that first. She actually tells you that she grabs the necklace. And I wrote it down because I thought this was so interesting. Just a second. She downplays it. She says she reaches for the necklace to try and get away. That's odd. You don't reach for something to try and get away. On cross-examination, we find out that she was angry. She was angry and she grabbed that necklace because she had bought it for him. And so was that the initial aggression? We don't know because we couldn't see the body worn camera and the state hasn't proven it to you. We don't have to prove to you exactly what happened. So she says it's a spit and a slap. And then she says, well, yeah, you're right. It was a spit, grab of the necklace, and then a slap. Was Bridget a witness? He says yes. What hand? This is consistent. All this is consistent. And she even tells us it's the left side of her face, open, and it's a slap, right? But then we hear on August 17th, when she's talking about August 9th, she actually tells officers it's the right side of her face. It's less than 8 days later, and she's saying it's a different side of her face that he injured. Why isn't she being consistent? Why isn't she telling the same story 8 days later, much less 9 months now? So then let's move to August 17th. On August 17th, the officer tells us that, yeah, they both confirmed it was that date. And Bridget didn't see anything, so she doesn't know where it happened, the order of events, what hand, what side of face, close or open, hit or punch. But he says that he talks to Bridget and she was there. And she saw him. Well, that's weird because Bridget testifies and she says, no way, didn't see him at all that night. Didn't see him at all. Then the officer doesn't really tell us anything else about what Bridget says. But then we get into what Sabrina says. And we've already said that Sabrina and the officer confirmed same day. And the order of events, the officer says it's kind of the same. We'll get to that in a second. Was Bridget a witness? He says, no, she wasn't a witness, or he says, yeah, she was a witness. He doesn't tell us what hand. He doesn't tell us what side of the face. He says it's a punch. And the last thing that's a little different on this one, how he got in, how Todd got into the house. And this is different too. These are inconsistent. These two are inconsistent. And he says that makes him not necessarily believe what Sabrina's saying. So then finally we get to Sabrina. And Sabrina tells us it's August 17th, but we find out that's actually not true.
5 minutes.
Right? We found out that's not true. It was the day before. Where it happened, we don't find out anything different. Order of events, we don't find out anything different. What hand, what side of the face, closed or open, hit or punch, how he got in, we don't know any of that. She tells us different things, and she is so ready to change her story. When I started pointing out inconsistencies when she's sitting up on the witness stand, she said, yep, he hit me with the right hand. And I said, well, how does that make sense? He's reaching over you. And she says, oh, it must have been the left. Details like that are important. Little details can be different. Absolutely, understandable. But would a complaining witness who is saying this happened to her be so ready and willing to just change her story? Oh, you know what? Maybe I was wrong. Maybe it was the other hand. Maybe it was the other side of my face. Maybe I actually did grab him first. Maybe when he grabbed me, I came down hard on his arm and then he hit me. Because she did that in both situations. On August 9th, she leaves out that she grabs the necklace first. And on August 17th, during direct examination, she leaves out that she came down hard on his arm. She doesn't tell us that until cross-examination. Why is she leaving those details out? Because it shows her as the initial aggressor, and she's afraid she's going to get arrested. Officer Lopez tells us that he's been there lots of times before. This is an individual who has had a lot going on in her life. But when she can't get the details straight, she couldn't get the details straight between the offenses, then that, ladies and gentlemen, are bricks. All of these inconsistencies are bricks. Whether or not he grabbed the necklace, Bridget doesn't even tell us about the necklace. In fact, Sabrina tells us Bridget doesn't see it because she was trying to protect her child. And at the end of the day, Sabrina tells us that she was scared of him, right? She's scared to run away. She runs to her bedroom, but she leaves her 6 children outside with a person she says just attacked her, with her other child that's supposed to be defending her. This is someone that's not being consistent with what they're telling you. When you go back to the jury room, you're going to look at the charge. And I want you to think about all these bricks, all the evidence they didn't bring you, all the inconsistencies, and whether or not Sabrina was credible. Because at the end of the day, that's what I asked you on day 1. Remember, this is a he said, she said story. Gonna come down to credibility. And when your story is that different and it's gonna change at the drop of a hat, how credible is that? So you're gonna look at these verdict forms and we're gonna ask you, based on the fact that there's so many bricks, that burden wall is so high, that the state, they're not overcoming that, they're not getting past that, and to find Todd Dotson not guilty, count one. And then we're gonna ask you, and that's the first line of the verdict, to move on to count two. And say the same thing. There's too many bricks and they can't go beyond that wall that has been built. Been built on their own failure to bring evidence to you. So when you go back to that jury room, that's what we're gonna ask you to do. Ask you to fully examine the evidence and to hold on to your verdict because it requires a unanimous verdict. And if you can't be unanimous, then a mistrial is declared. Now that means we try the case again, that's true. But it also means that a wrong verdict was never.
Objection,
bartered for.
Your Honor, improper argument.
Sustained.
Now I'm gonna sit down in that chair and I'm gonna have to sit on my hands. Because we're gonna hear a lot of stuff from the state in which I not only don't agree with,
Objection, improper argument.
Sustained.
and I'm gonna try not to make faces.
Objection, improper argument.
Sustained.
And when they're done, I want you to think about all those bricks. All those bricks in the wall that they just have not overcome and find Todd Dotson not guilty on count one and count two. Thank you.
Wait, you have 11 minutes remaining.
Thank you. May we ask the council to please remove the. Thank you, Your Honor. Members of the jury, we're here to talk about two dates, the 9th and the 17th, okay? You're gonna see basically this page 6 and page 7. Count 1 is really kind of clearly explained right there. And count 2 is really clearly explained right there, okay? You'll see for both pages 6 and 7, you're gonna have to look at a prior, and that's all the stuff, a prior conviction. That's all the stuff that my partner Travis did today. Okay, you'll have that in evidence, all right? And with respect to a family relationship, you'll see the word family kind of all throughout the document. It's pretty much incontroverted that they had a relationship at the time.
Objection and proper comment on the evidence. All right, that'll be overruled.
So let's talk about the 9th first. Okay, let's just walk through January 9th. With what you guys have seen in the courtroom, okay? First person we put on the stand was Miss Lasagna Robinson, right? She authenticated the 911. It's a lot of legal processes. And you guys are gonna get to listen to the 911 phone call when you go back there. So you're gonna have it, you're gonna have access to it. And we're gonna talk more about the 911 phone call from January 9th in just a second. Next, we put up Officer Franco. Now, Officer Franco did a great job of meeting the initial elements on or about a certain date in Bear County, the defendant, right? He said the date, the scene he arrived to in Bear County, Texas, and he correctly ID'd the defendant, right? Remember, he was kind of like right next to his car before the defendant ran away. On or about a certain date in Bear County, the defendant. So Officer Franco met that need. He met those elements. Everyone else also talks about the dates and the time in Bear County and the defendant, but also great to have the primary reporting officer from that day take the stand under oath and tell you what he observed, okay? Then we put up Bridget, the sister-in-law, the eyewitness, and she had mentioned that when everybody left the room, that she saw the defendant spit twice, right? Not 2, 3, or 4 times, twice in the face of the complainant, and that she also witnessed the defendant slap the complainant across the face. And then Sabrina went back to the room, right, and called 911. that directly corroborates, again, we invoke the rules, so multiple people couldn't hear multiple people's testimony, right? So that was Bridget, again, the sister-in-law, the eyewitness. Then you had Sabrina come in, and she pretty much corroborated that exact account. She also corroborates her 911. But she corroborates also what Bridget said. After the verbal argument, she was spit in the face twice, again, not 3 or 4 times, but both said twice, and she was slapped in the face. And again, the 911 phone, on the 911 phone call, you'll hear the instance of spit in the face. I was spit in the face, I was slapped. So across all time frames and people, that account is incredibly consistent. And you heard all kinds of discussion about left hand, right hand, chain this, chain that, but never, ever, not once was there a debate about the slap taking place. That is what is most critical to focus on. The elements are, again, assault causing bodily injury, you'll see it. Not once was there even a debate about whether or not the slap took place, okay? So that is gonna be, again, January 9th. On or about that date in Bexar County, the defendant caused bodily injury. All you need is pain. Again, that's the threshold under Texas law. Cause bodily injury to the complainant by taking an action. The action here, again, chain this, chain that, the slap. There was no debate about that, okay? That's January 9th. Now, let's go to January 17th. Again, I'm kind of splitting it, but let's go to January 17th and let's just kind of walk through again what y'all heard while you were in court, okay? So again, Miss LaSonia Robinson, she was the custodian. It's very legal, but she basically authenticated the 911 phone call through processes. You're gonna have the phone call from 911 on the 17th as well. You're gonna have it back there. We'll talk about that in a second. But that's the first person you heard from. And then, going a little out of order, you also heard from Officer Lopez, the primary reporting arresting officer from January 17th. Very similar, parallel to Officer Franco, right? He can testify to honor about a certain date in the county. The defendant, right? He identified the defendant, unlike in the previous January 9th, where the defendant ran away, but there was still an ID. In January 17th, there was an arrest date. So again, it's perfunctory, it's simple, but it's important to meet every single element beyond a reasonable doubt. Officer Lopez helped that, right? On or about a certain date, he arrived at the scene in Bexar County, Texas. He ID'd the defendant. But Officer Lopez actually provided a little extra clarity. I think he was able to kind of speak a little bit more to some of the nuance and important things. And what I mean by that is, on cross-examination, there was all kinds of discussion about whether or not the bruising was a concern, the temporal, the time aspect. Without missing a beat, he was like, no, there was.
Objection and proper characterization of the evidence.
All right, ladies and gentlemen, you will remember the evidence as you received it. You may continue.
Without missing a beat, he said, no, no issue.
And proper characterization of the evidence.
Ladies and gentlemen of the jury, you will remember the evidence as you received it.
On cross-examination, it also came out that the CW, the complainant, all kinds of verbiage, but the complainant, Sabrina, was unsure how the defendant entered the apartment, the dwelling that night, but it was clear that it was without consent. And then towards the end, again, on cross, we got into the inconsistency. And the state really wanted to pare it down, right? What was the inconsistency? And again, it was to how they entered, not whether or not the altercation took place.
Objection and proper characterization of the evidence.
All right, ladies and gentlemen, you will remember the evidence as you received it.
And also, Officer Lopez, he made it clear that Bridget did not see the event, right? She was an eyewitness for the night. She saw the spitting and the slapping, but he told you that she didn't see it that night. So let's get into Bridget. Bridget, again, the sister-in-law, just for total clarity. She said that she sleeps in the living room and Sabrina sleeps in her room. And I know I'm a broken record, but she didn't see anything that night, all right? And she made it clear when she took the stand that there was actually kind of 3 points of entrance to the home. And very kind of passively, she just said, well, he could have exited through the back door and I wouldn't have seen him. I think that's really important, right? There was no opportunity to really lie. She just said what happened to her, right? Hey, on this date, yeah, I saw it. But on this day, hey, I sleep in the same house, I didn't see it.
Objection, bolstering the witness. Counsel does not get to vouch for the credibility of the witness.
Overruled.
Let's round things out. We've talked about the 9th. Again, let's round things out with the 17th. Let's talk about Sabrina. Let's talk about the complainant. She was unsure how the defendant got into her room that day, but after a verbal altercation, she essentially stood up to change the light. And you're gonna have that evidence. You're gonna have a picture basically just of the room, just for context. We wanted you to see the room, you'll see the light hanging above. And she testified that essentially he grabbed her lower area hard and that she felt pain. And then essentially he swung and punched her in the face. Okay, now we have photos of that, right? We also have some photos of the 9th, but with respect to a slap, it's much harder. Whereas with a punch to the face, and again, it was the next day, gives that time to build up. We have photos of the bruising from that day. You're also gonna have that 911 phone call. So on top of the photos from the 17th that would show the that would show that bruise, we also have the 911 where she says on the 911 that he grabbed my middle area. He grabbed it really hard. He swung at me in my face. There's a missing key, missing house key, right? All that cooperation with. Doesn't know how he got in there. He got in there. He, of course, being the defendant, okay? And very, very, very similar to the 9th, right? How not once was there a debate about the slap just taking place. That really wasn't the crux of any of the discussion here. It was things on the outside, not did that act take place. Very similar here. Whether the complainant was facing this way or that way, or the arm on the way down, they never, ever, not once was it debated that the grab took place and that the punch occurred. That is what is important. So again, with respect to both counts, the 2 counts that you're going to see here, the state had to prove the family relationship. Right, so for 17th over here, 9th over here, a family relationship, the underlying sentence, you'll have all that, again, what Travis did earlier on today. And again, on or about a certain date in Bexar County, the defendant caused bodily injury, and you only be paying under Texas law, to the complainant by taking an action. We respectfully ask that you find the defendant guilty on both counts.
All right, ladies and gentlemen, Deputy Laura will take you back. Deputy Laura. All right, everyone, please rise for the jurors.